Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, Florida. Yes, we get to talk. You don't end up getting talked about here a lot at Washington Gun Law because, well, you do a pretty good job of letting your citizens live free like Americans. And even though you are considered to be an incredibly pro-Second Amendment state, I did a little digging around and you got some kind of weird gun laws down there, including one where you don't permit open carry. Hey, I got news for you. Even Washington State permits open carry. So what's up with that? Well, it appears that someone decided that, hey, you know what? We're going to file a lawsuit on it. And then it appears that state government never responded to it. So we're going to get to talk about a new term that we haven't really talked about here before, which is a default judgment. But is this the beginning of something really big in Florida? Maybe. We'll dig into it and we'll geek out on it together. So today, let's spend a few minutes and let's talk about how this little judgment in Florida could lead to open carry statewide. Okay, and today's video is brought to us okay, so hey, listen, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by, but don't tell anybody, Taylor Freelance. Now, we would love to show you all the cool things that Taylor Freelance is making right here in the United States of America. That's right, because they're based right there in Bellingham, Washington. But here's the deal. If I start showing you all the cool stuff they're making, well, then Google and YouTube, they're going to kind of crap their pants. Let me just say it this way, though. They don't make firearms, got that, Google? But they will make your firearms a lot better. So whether you're looking for base plates, brass back straps, or any other component to make your firearm better fit for your use, well, then you need to go visit my good friends at Taylor Freelance. Now, normally I'd just go ahead and run the little link right down below, but yeah, you see, Google get a little pissed about that too. So instead, that's a link to our partner page right there. You can go there and then you can find the good folks at Taylor Freelance and check out all the cool stuff that they're making, because you know it's cool if YouTube doesn't want it here. Okay, America, here's the case we're talking about today. We're talking about the case of Gun Owners of America v. Pearson. It is a case that was filed against the St. Lucie County Sheriff, Sheriff Pearson, and challenges the Florida law which prohibits the open carry of firearms unless you are engaged in the act of hunting or fishing. Now, I decided to do a little geeking out, took a look at Florida gun laws, expecting them to be very, very freedom-loving, and for the most part they are. But yes, Florida has some weird gun laws, including the fact that even though they're constitutional carry, that does not mean you can open carry, which then begs the question, do you really have constitutional carry? But I digress. Now here's the thing. This lawsuit was filed back in August, and just so you know, when plaintiffs file a lawsuit and then serve that lawsuit on the named defendants, the defendants have a certain period of time to respond to the complaint. They may ask for additional time in that time, or they usually respond with an answer that says, hey, this is all BS, and here's why the lawsuit should be thrown out, and here's why we're going to win anyways, and et cetera, et cetera. Now, when a defendant just so happens to not respond at all within the time period, the court is permitted by court rule to enter what's called a default judgment. And a default judgment is exactly what it sounds like, which is the court awards judgment to the side that actually did respond to the court. In this case, that was the plaintiff. So the plaintiffs filed their complaint. We're going to actually go through the complaint here in a few minutes. And the defendants, and in this case, the defendants were two named defendants, and they were Sheriff Keith Pearson in his official capacity as the sheriff of St. Lucie County, and Thomas Bakedahl in his official capacity as the state attorney for the 19th Judicial District of the state of Florida. But here's the thing. Neither of those named defendants have responded to this complaint. And now the court has entered a default judgment. It is right here. And the default judgment of the court reads as follows. This cause came before the court sua sponte. Proof of service on defendants Sheriff Keith Pearson, St. Lucie County Sheriff's Office, Thomas Bakedahl, and the State's Attorney Office for the 19th Judicial Circuit has been filed on the record indicating that defendants were served with process, and the deadline to respond to the complaint was August 30th, 2024 for the State's Attorney's Office for the 19th Judicial Circuit and Thomas Bakedahl, and September 3rd for Sheriff Keith Pearson and St. Lucie County Sheriff's Office. To date, defendants have failed to answer or otherwise respond to the complaint. Therefore, it is hereby ordered and adjudged as follows. And so this is the ruling of the court so far. And this is not the end of it, but this is what the court has ordered so far. The clerk of the court shall file an entry of default against defendants Sheriff Keith Pearson, St. Lucie County Sheriff's Office, Thomas Bakedahl, and the state's attorney's office for the 19th Judicial Circuit pursuant to Rule 55A of the Federal Rules of Civil Procedure. Okay, now if you take a look at the federal rule, yeah, the defendants can respond and ask that the default judgment be withdrawn, but only if they show that there was really good cause for them to have not responded within that time limit. And considering who the named defendants are here, it begs the question, how is it that they would have good cause and yet never communicated with the court prior to that? Now, is it possible that these named defendants actually do believe that Florida's law is in fact unconstitutional and intentionally did not respond? I don't know about that. I don't know enough about the inner workings. The question is now that we have a default judgment, what's the remedies going to be? Because as we talk about here all the time, winning a lawsuit doesn't mean jack squat unless you get some remedies. So in order to figure out what remedies are available, one should probably take a look at what the original complaint alleged and what it asked for. And I had an opportunity to read this, and I got to tell you, it's a really, really well-drafted complaint. And then I took a look at the author, and it happens to be a personal friend of mine, an attorney down in the Orlando area named James Phillips. James, nice work on this. You did a really, really bang-up job with this brief here. So, of course, then the question is what exactly were the plaintiffs arguing for? And one would hope they were saying, hey, you know what? The law that bans open carry in Florida, yeah, it's unconstitutional. It violates the Second Amendment. So as we go through the plaintiff's original complaint, what do we look for? Well, we look for those types of allegations. And guess what we find? First, being law-abiding adult American citizens, plaintiffs undoubtedly belong to the people. Well, that sounds like the beginning of a Second Amendment argument. Second, plaintiffs seek to bear arms because they wish to wear, bear, or carry handguns upon the person for self-defense in public. And much like how nothing in the Second Amendment's text draws a home public distinction with respect to the right to keep and bear arms, nothing in the Second Amendment's text distinguishes between open or concealed carry, so the amendment presumptively protects both. Oh, now we're definitely sounding like a Second Amendment argument, aren't we? Third, and finally, plaintiffs wish to carry handguns, an instrument that constitutes bearable arms. Handguns are not just presumptively protected, but already conclusively so. Oh yeah, I think we're getting exactly where we need to be. And then, of course, they wrap it up with, having established plaintiffs' presumption of constitutional protection in openly carrying handguns for self-defense in public, Florida Statute Section 790.053 sub 1 may be upheld only if defendants prove it is consistent with this nation's historical tradition of firearm regulation. Oh yeah, we are definitely full speed ahead now with a Second Amendment challenge to this open carry ban. And of course, as the plaintiffs very correctly pointed out, applying Heller, Bruin, and Rahimi, Florida's open carry ban is unconstitutional. As explained above, any firearm regulation which restricts members of the people from keeping or bearing arms is presumptively unconstitutional. And then, of course, in case there was any doubt, they finally just point out Florida's open carry ban violates the plain text of the Second Amendment. Florida Statute Section 790.053 sub 1 violates the Second Amendment by infringing on an individual's right to bear arms outside of the home. Okay, so then of course the big thing is remedies, right? What did they want this court to do? Because now with the default judgment, theoretically, the court could in fact impose any of these remedies. And yes, it is what you are hoping for. A, declare that Florida Statute Section 790.053 sub 1 violates the Second and 14th Amendments to the United States Constitution and therefore is unconstitutional. B, preliminarily and permanently enjoin defendants, their officers, agents, servants, employees, and all persons in active concert or participation with them from enforcing Florida Statute Section 790.053 sub 1. So yes, could the court theoretically permanently enjoin this statute because of the default judgment that it has now entered? Yes, all of that is procedurally and legally possible. Now, whether or not that is likely to occur, that's probably a question that's better for Mr. Phillips. Maybe we'll get him on the channel. James, you know how to get a hold of us. Listen, bottom line is this is really, really terrific work by plaintiffs' counsel here. This is a huge win. This was brought to us not only by the attorneys that I've already talked about, but also by the Gun Owners of America and the Gun Owners Foundation, which means, of course, we're going to put links down below so you can show both of those fine organizations some love as well. This is not the end of the story. I'm sure we'll be doing more videos, but hey, Florida, perhaps this is the beginning of something really, really awesome. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, go ahead and click on that link right there. Let us know what your idea is. It's probably way better than any idea we've come up with lately. Maybe you just want to subscribe to our monthly newsletter. The ability to do that is all down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.